Supreme Court Justice Clarence Thomas leaned forward with a smirk. Congresswoman, with all due respect, a law degree from Thurgood Marshall doesn't exactly prepare you for constitutional debate, he said, his voice dripping with condescension. The hearing room fell silent. Cameras zeroed in on Representative Jasmine Crockett's face, waiting for a flinch, a stumble, any sign she'd fold. But what happened over the next 30 seconds didn't just leave Justice Thomas speechless. It sent shockwaves to the legal world and became the most-watched congressional exchange of the year. That moment stunned legal scholars, reframed how America looks at credentials, and proved why you should never underestimate someone who fought their way to the top. You're watching Justice Land USA and Updates. Before we break down what Crockett did next, the moment that made even Thomas's supporters gasp, tap like and subscribe to Justice Land USA and Updates. This is what happens when arrogance meets preparation, and why this exchange will be dissected in law schools for years. Trust me, you don't want to miss the moment everything changes. If you've ever been underestimated, this one's for you. To understand why this clip exploded across the internet and changed minds far beyond Capitol Hill, you need the backstory. Justice Clarence Thomas wasn't just any justice. He's the court's most senior member, serving for more than 3 decades since his contentious 1991 confirmation. Known for sharply conservative opinions and rare but pointed questions, Thomas earned a reputation for dismissing legal perspectives that don't fit his originalist lens. Congresswoman Jasmine Crockett represents a newer generation. Before Congress, she worked as a civil rights attorney, taking cases that touched real lives. While Thomas moved in Washington's elite legal circles, Crockett spent years in courtrooms, standing up for clients who couldn't afford high-priced counsel. The hearing that brought them together was supposed to be routine. The House Judiciary Committee invited Justice Thomas to discuss Supreme Court ethics reforms amid controversies over undisclosed gifts to justices. No one expected it to get personal. The clash was almost inevitable, a collision between different legal worlds. Thomas embodies the entrenched elite with unspoken hierarchies. Crockett embodies results-oriented practice, the kind that elite gatekeepers too often overlook. We often confuse credentials with competence, Crockett had said in an interview weeks before. We mistake where someone learned for what they've actually accomplished. She had no idea how prophetic that would be. From the start, the tension was palpable. When it was Crockett's turn to question, observers caught Thomas's subtle tell, a slight stiffening, a hint of dismissal. It's a look many people from non-elite backgrounds know too well, the one that says, "You don't belong in this conversation." What about you? Have you seen that look? Drop a comment if you've ever felt someone decided you weren't prestigious enough before you even spoke. The room buzzed with low murmurs as Justice Thomas adjusted his microphone. CSPN cameras panned the chamber, capturing a packed gallery of legal observers, journalists, and staffers leaning in. The gentlewoman from Texas is recognized for 5 minutes. The chair announced, his gavel cutting through the noise. Crockett began with impeccable restraint. Justice Thomas, thank you for appearing today. I'd like to discuss your interpretation of the Emoluments Clause as it relates to judicial ethics. Thomas nodded, expression neutral but detached. I'm familiar with the clause, Congresswoman. I'm sure you are, Crockett replied, professional and composed. After all, you cited it extensively in your concurrence in Howell v. Department of the Interior. She then referenced specific passages from Thomas's own writing, quoting his words verbatim, noting page numbers, without looking at notes. She had them memorized. Thomas's expression shifted. This wasn't the surface-level sparring he'd expected. In that opinion, Crockett continued, you wrote that government officials must avoid even the appearance of financial conflict. Yet recently, in your statements to the Senate, you suggested that disclosure requirements for justices should be more limited than for other officials. Could you reconcile those positions? Thomas cleared his throat. Congresswoman, you're conflating 2 different legal standards. Am I? She replied evenly. On page 47 of your Howell concurrence, you drew parallels between those standards, writing, and I quote, the constitutional requirement for all federal officers applies with particular force to those entrusted with judicial review. Those are your words, Justice Thomas. The camera caught a flicker of recognition. She was precise, and they both knew it. For the next 3 minutes, Crockett built a careful, escalating case, pointing to what she described as inconsistencies between Thomas's written opinions and his recent public comments about judicial ethics. What we're really talking about, she said, is whether the standards you've eloquently applied to other federal officials should apply to Supreme Court justices as well. Thomas shifted in his seat. The dynamic had flipped. A junior congresswoman was demonstrating command of his own jurisprudence. "These are complex constitutional matters," Thomas replied, tone edging dismissive. "They require a nuanced understanding of separation of powers that might not be obvious to whom, Justice Thomas?" Crockett cut in. "Members of Congress? Civil rights attorneys? Graduates of certain law schools?" Silence. Then Thomas made a calculation. You could see in the narrowing of his eyes. "Let's be direct, Congresswoman. Constitutional interpretation at this level requires specific training and background. With all due respect, a law degree from Thurgood Marshall doesn't exactly prepare you for this depth of constitutional debate." He said it, on the record, for the cameras, and the millions who would soon watch online. A Supreme Court justice publicly dismissing a congresswoman's credentials based solely on where she studied. The room went still. Heads turned. The chair looked up, surprised by the personal turn. Crockett was motionless for a beat, not angry, not embarrassed, but almost expectant. Those who knew her recognized the look. She'd been waiting for this moment her entire professional life. "Mr. Chairman," she said calmly, "I'd like to respond to Justice Thomas's comment about my qualifications." "The gentlewoman may proceed," the chair replied. Crockett looked Thomas in the eye. "Justice Thomas, before I address your remark about my education, I want to clarify something. Are you saying my analysis of your own written opinions is factually incorrect? Because I can provide the citations again." A strategic pin, either concede her accuracy or claim she misquoted him, something the record would demolish. Thomas shifted. "I'm suggesting that there are nuances to constitutional interpretation that require particular training." "I see." Crockett nodded. "And what specific part of my analysis lacked nuance? My direct quotation of your concurrence? My reference to the history of the Emoluments Clause? Or my question about the apparent contradiction in your positions?" The trap snapped shut. He'd attacked her pedigree, not her argument. Now she was pulling him back to substance. "While you consider that," she continued, reaching for a folder on the table, "let me address your comment about my alma mater." The movement was deliberate. People watching would later say it was the moment they knew something extraordinary was coming. "Justice Thomas, are you familiar with Thurgood Marshall School of Law's constitutional law program?" Silence. "Then perhaps you're unaware that our constitutional law program requires more credit hours than Yale's," she said matter-of-factly, "and that graduates from historically black law schools like Thurgood Marshall pass the constitutional law portion of the bar at rates comparable to schools you might consider more prestigious." His face stayed fixed, but a muscle tightened in his jaw. "But since you've raised my qualifications," Crockett continued, opening the folder with unhurried confidence, "let's talk about my record rather than assumptions about where I studied." The air crackled. Legal analysts on the live stream started typing furiously. This wasn't just another hearing. This was about to redefine how America talks about credential elitism. How many of you have been in Crockett's position? Judged not by your work, but by your school or your zip code. Ever had someone dismiss you before they knew what you could do? "Justice Thomas," Crockett began, voice measured but ringing through the chamber, "since you question whether my education prepared me for constitutional debate, here are a few facts." She laid several documents in a careful row, the cameras capturing letterheads and seals. Thomas's expression shifted again, annoyance and a flicker of uncertainty. "After graduating from Thurgood Marshall School of Law," she said, "I argued Thompson versus Dallas Housing Authority before the Fifth Circuit Court of Appeals. Are you familiar with that case? A landmark in housing discrimination. Scholars watching instantly recognized it. That decision established new constitutional standards for applying the Fair Housing Act to municipal zoning," Crockett explained. "It's been cited in 47 subsequent federal rulings and is now taught in constitutional law courses at 23 law schools, including Yale, Harvard, and Georgetown.